Uganda versus Honorable Muwanga Kivumbi.
Please, Your Worship. Nabasa Salama, Mr. Tatoni. Appearing together with the Assistant DPP, Rachel Bicoli, for state. I'll leave the defense to introduce themselves.
My name is Samuel Muwanga. Appearing jointly with the Learned Paul Muchibi and the Learned Kenneth Paul Kakane, Joint Counsel for the accused person.
Your Worship, the matter is coming up for ruling, and we are ready to receive the same.
Ready.
Void criminal case number 01126 of 2026. Muwanga Kivumbi stands charged with incitement to violence contrary to section 79 of the Penal Code Act and managing unlawful society contrary to section 53 of the Penal Code Act. Prosecution raised a preliminary issue for court to issue an in-court protective measure to avoid live streaming. In support of this application, the Learned Counsel, Rachel Bahole, leading the prosecution team, relied on Article 28(2) of the 1995 Constitution, submitted that though the Constitution provides for public hearing before a court, nothing shall prevent the court from excluding press, the public from all or any proceedings before it for reasons of morality, public order, national security, as may be necessary for a free and democratic society. The prosecution went ahead and relied on the aspect of public order and national security. Prosecution submitted that charges against the accused person are inciting violence and managing unlawful society, and previously he was accused with charges of terrorism, which cases are still ongoing. Further, prosecution submitted that these cases involve matters of public safety. Broadcasting the proceedings live may compromise witness safety, expose witnesses to intimidation, and influence the public in a manner prejudicial. The prosecution further submitted that exclusion of media does not derogate from the accused constitutional right to a fair hearing, but rather ensures that the trial or court proceedings proceeds in a manner that balances the preservation of public order, national security, and integrity of the judicial process. In response, Learned Counsel Medard Segona referred to Article 28.1, Article 28, Clause 1 of the Constitution, and he further stated that State brought this application in a casual manner without formal application, with no supporting evidence. Counsel submitted that the right to a fair hearing is a guaranteed right and referred to Articles 28.1, 28.2, 42.1, and 43.1 and 43.2. That matters of national security cannot be speculatively tagged to a particular witness or office of court. It was speculated that witnesses might be intimidated. Counsel submitted that the burden of proof to justify this application lies on the state to establish necessity, proportionality, and minimal impairment of the right of the accused to a public hearing. Reference was made to the cases of Charles Onyango Obo and another versus the Attorney General Constitutional Application Number 2 of 2002, and specific reference was made to the judgment of Sekoko at page 7. Further, Land Counsel Medard submitted that Section 40 of the MCA provides the court power to give orders for the exclusion of the public or a particular person not to have access to the courtroom with justification. The statutory provision must be construed in a manner consistent with the Constitution as provided under Section 274 of the MCA. Lead Counsel Medard Segona further submitted that nature of offences charged against the accused person cannot be used as a bar to deny public access. He referred to Section 41 of the Access of Information Act. Several authorities were stated in support of their argument. In response, the state emphasized their original position of seeking an in-court protective measure against live streaming. They submitted that it would compromise the proceedings prejudicial to fair administration of justice. Further submitted that the state did not pray for a closed trial in camera proceedings, but rather court to regulate one particular mode of live streaming of proceedings because they present distinct risks to the trial integrity of the proceedings and orderly administration of justice. What defense has done, they have raised their own issue in reference to a closed trial in camera proceedings. They have made reference to state's application not being formally filed. They have not given the law on formality. No law bars or application in a matter of this nature. State referred to Article 126 of the Constitution that substantive justice shall be administered without undue regard to technicalities. Further, state submitted that Article 28.1 of the Constitution does not guarantee the right, that the constitutional guarantee of a public hearing does not provide an automatic right to live streaming. The distinction between public access to court proceedings and live transmission of proceedings is very important. Court's analysis. Court looked at Article 28.1 of the Constitution that guarantees a public hearing. However, the right to a public hearing does not create an automatic right to record, broadcast, live stream proceedings. Section 40 of the Magistrates Court Act gives the power to the court to control the manner in which proceedings are conducted. subject to the Constitution and the law. Cameras and phones may therefore be permitted in court by the leave of the presiding judicial officer and subject to conditions of the judicial officers sees appropriate. The judicial officer presiding over the matter is responsible for maintaining integrity, orderly conduct, and dignity of the proceedings. The Judicature Electronic Filing Service and Virtual Proceedings Rules 2025 also requires the use of technology in judicial proceedings. Specific reference made to Rule 6.1, which requires the approval of the presiding judicial officer before technology is used in court. While the present court does not have an electronic recording system, and therefore there is no official electronic court recording, to which competing recordings can be compared, the underlying principle remains relevant. The use of technology in court is subject to control and approval of the presiding judicial officer. Open justice means that public may ordinarily attend and observe proceedings. It does not necessarily mean that proceedings must be broadcasted live. Court has to balance the legitimate interests in transparency, public access, against the court's overriding responsibility to ensure a fair, orderly, and dignified hearing. Court's decision. The court has taken into consideration the submissions of both learned counsel, the law, and it hereby orders that the application succeeds. Hearing of both bail and trial shall remain open to the public and accredited members of the media. Live audio recording, live video, live streaming from inside the courtroom is prohibited. Fair, accurate, text-based reporting of proceedings had in open court is permitted, subject to the law of contempt and the rule of sub judice. Media attendance is subject to court verification by court administration, not as a device of exclusion, but for order, space management, and security. All counsel, parties, supporters, bloggers, journalists, and members of the public are directed to refrain from the commenting on the merits of this case before the conclusion of this matter. I hereby order. Counsel? You have a pending application on bail. Can you refer to that?
This matter was adjourned earlier for us to respond to the bail application. We filed a written response to the bail application on the 12th of August. Your Worship, the respondent objects to the application for bail and prays that the applicant be denied bail. We rely on the affidavit of Detective Corporal of Police Muhwezi Abati.
proceed.
Yes, as noted by the state, they filed a written reply. It follows that we are entitled as of right to respond to their reply by way of rejoinder. It appears the state has started submissions and reply. Hours is on record. To seek your indulgence, will permit us to file our rejoinder together with the written submissions in rejoinder. It's only then that we shall properly, adequately, and effectively execute our instructions. This we can do in one day. Enable this matter be expedited. We will sit for one day tomorrow, and this will be filed by Thursday.
Objection upheld. You're filing your rejoinder on Thursday?
Tomorrow, actually, the reason why we wanted it is because the rejoinder will be signed by him. So by tomorrow we can file by end of by close of day tomorrow. By for that purpose, Thursday. Affidavit in rejoinder together with the submissions. Yeah, most of that. We can be served here and now.
Your Worship, we served the written.
No, maybe let's be clear, Your Worship. State is mixing two things, affidavit in reply and written submissions. What you served was an affidavit in reply. Are these submissions? We have not received submissions.
I have on record the respondents' submissions.
Worship, we served counsel who signed this counsel on the 14th of August. He signed for the same. So we've served them with the affidavit and also the respondents' written submissions in objection to the bill. We served both of them.
And then they mix, because she had earlier started submitting, yet they have written what? Submission. Does that mean state is also going to make an oral in addition to written, or we just respond to this so that you have the record clear? Then because you have already written submissions that reply, so respond to this.
Council raised an objection and it was upheld.
Yeah, we are obliged and we will seek the permission of court if the state is uncomfortable to get a copy from the court file. Yes, they will give us.
But your lead counsel side is received.
No, for us to state that we do not have it on our file is sufficient. Probably the Honorable Senator is out of jurisdiction now. We want one day, under such circumstances, that we seek the permission. If the state does not provide, we shall
So you're filing rejoinder by 27?
By 27th, we are filing both the affidavit and rejoinder together with written submissions and rejoinder.
Will you expect to reply to the...
Yeah, I'm right.
Have no right.
That would be a Saturday.
Then we shall have the ruling on 3rd of September. At 10.
Nga 3 omwezi ogw'omwenda kkooti egenda okuwa ensala olw'omubaka bamweyimirira oba nedda, n'ekirala kkooti egaanye okukwata butereevu ebigenda mu maaso mu kkooti, naye tegaanye bantu ba bulijjo okubeera mu kkooti, muli baddembe okujja mu kkooti.
The lawyers will explain to the person.
Counsel, you explain to them.
But we are very firmly presenting some